Ladies and gentlemen, please welcome the moderator of our first panel this evening, the Chief Legal Counsel of Alliance Defending Freedom, Jim Campbell, along with our distinguished panelists, John Bursch, Senior Counsel and Vice President of Appellate Advocacy at Alliance Defending Freedom, William Bach, Partner at Kroger, Gardis, and Regas, and Aaron Morrow-Hawley, Senior Counsel and Vice President of the Center for Life and Regulatory Practice at Alliance Defending Freedom.
All right, can you all hear me? It doesn't sound like you can. We'll trade. How about now? Still doesn't sound like it. Testing. John?
Test.
There you go.
I told him the names. I don't
All right. Well, we'll get started here. So you've heard the introduction of all of our panelists, but let me give you a little more information about them and why they're qualified to talk about what happened at the Supreme Court today. So Erin, sitting right next to me, knows a thing or two about the United States Supreme Court. She clerked there for the Chief Justice, John Roberts, and she's also argued a couple cases at the Supreme Court, most recently just last month. John, next to her, is the head, as you heard before, is the head of appellate advocacy at Alliance Defending Freedom. He's argued 13 cases before the U.S. Supreme Court, and he is part of the legal team that defended the Idaho and West Virginia laws in court today. And lastly, we have Bill on the end, and Bill is a nationally recognized expert in sports law and Title IX. He previously served on the NCAA Division I Committee on Infractions, and in that role, 2 years ago, he voluntarily resigned in protest over the NCAA's current, at that time, current policy that allowed male athletes to participate in female sports. And at the time, he called, yes, that's worth clapping over. And at the time, he wrote a letter to the NCAA, and he called that policy institutionalized discrimination and sanctioned cheating, which I think is an apt description. So without further ado, let's talk about what happened at the Supreme Court today. John, let's start with you. I, as an observer of the argument, was shocked at some of the arguments that were being made by the ACLU's legal team. I want you to talk a little bit about what you heard them argue before the justices today.
I've listened to hundreds of U.S. Supreme Court arguments, and I've never once heard an advocate stand up and said, oh, you know how we won summary judgment below? You should just vacate that because that was wrongly decided. That was incredible. And that was one of many unbelievable moments where they were just running away from the merits arguments as fast as they possibly could. Another extraordinary moment is when they said, we don't want you to say what sex means under Title IX, and we don't have a definition either. Well, think about how incredible that is. Here we're talking about a case where the whole issue is about biological distinctions between males and females, and they don't know what sex means. And when you don't know what sex means, it's really difficult to have an argument about Title IX and the Equal Protection Clause. So for them, it was just a downhill slide that just got worse and worse the more that they talked. It was a really rough day for the ACLU. We feel really bad about that.
All right, Aaron, we'll go to you. Talk a little bit more about that issue. You and I had a conversation earlier today where you pointed out to me some of the shocking things you heard in the argument today. So tell the audience about that.
Sure. So to follow up on what John said, ACLU really was running away from positions that they'd even advocated in their briefs. So one of the most surprising things to me was their statement that it was okay if Idaho and West Virginia's law made distinctions based on transgender status. They said that was fine. All they were asking for was a narrow exception for transgender athletes who met certain qualifications and basically didn't pose a competitive disadvantage. Well, that blows a huge hole in their theory that West Virginia and Idaho's law were based on transgender discrimination. So just a crazy sort of 180 on what they were asking from the court.
Bill, let's go to you. You and I had a conversation, and we talked. Thank you. Does this work? I'm not sure. No, we'll stick with this one. You and I had a conversation, and we talked a little bit about the line that the ACLU tried to offer to the court. And so, again, the ACLU's team was in retreat. And they were arguing, well, you know, it's not that we have a problem with sex-specific sports. We just think there should be exceptions. So if, for instance, a biological male has low circulating testosterone, then in that circumstance, that particular individual should be allowed to compete in women's sports. And you're someone that knows a thing or two about sports policies and sports law. So tell me, do you think that that would be a workable solution?
Obviously, and can you hear me okay?
We got one mic.
So obviously that's going to be easy for high schools and elementary schools all across the country to administer. What's your circulating testosterone level? Because that's something I'm always up on, right? Particularly at age 63. But I, in addition to serving on the NCAA committee, I was the general counsel for the United States Anti-Doping Agency, and this is completely not how we look at sports in the United States, where any small amount of a performance-enhancing substance, which testosterone's on the prohibited list, matters, because minute differences matter in sports. So it's not fair. They suggested that what we're really concerned about is allowing less talented males to compete with the women, and they're not any better than, they don't have any advantages over the women. I mean, after all, the ACLU's attorney said some of these guys are tall, that makes them slower, and being from Indiana, I kind of went to the sport of basketball, and I thought I remembered that basketball kind of gave a preference or some advantage to taller individuals. So it doesn't make sense. But whenever you don't have bright lines, you're going to make it difficult on sport administrators. And what this really would lead to is the death knell of sports in America. You can't have sports when you have to draw lines for every participant in this fashion.
If I could just add one quick note to that. You heard Alan say at oral argument today, rightfully so, that there was a male athlete who suppressed testosterone for 2 years and had absolutely no difference in his race times. And we're all familiar with Leah Thomas at the NCAAs, who suppressed testosterone for 2 years, but because the difference between male and female swimmers is so large, still beat 2 women Olympians in the finals, 4 women Olympians total in that event. So the idea that somehow circulating testosterone is going to be the key to fairness in sports is just a lie.
There was a moment in the courtroom today when I personally wanted to stand up and cheer, which I resisted the temptation because I probably would have gotten kicked out of the courtroom. But that moment was when Justice Kavanaugh said something. And Justice Kavanaugh said, basically, when we're dealing with the issue of sports, it's a zero-sum game. If you take a spot and you allow a biological male to compete, you're taking that spot away from a girl who should have that opportunity. John, you and I have talked about that. What was your reaction when you heard Justice Kavanaugh raise that issue?
I did jump up and yell. Oh, no, I didn't do that. I was equally thrilled because it's easy to listen to a case like today and you're hearing all this stuff about intermediate scrutiny and as-applied stuff and mootness, and you forget what it's actually about. That it's about males identifying as women and girls and beating them in their own sports division. That's what the case is about. And Justice Kavanaugh brought that all home when he made the zero-sum game comment, that if a male athlete comes in and takes a spot on the team, it's a girl who loses that opportunity. When a male comes in and takes a spot at the conference championship, as happened to Adelaide in West Virginia, then she loses that spot at the conference championship. When someone like Leah Thomas takes the gold medal in the 500 meters, then a girl doesn't get that. In Connecticut, it was 15 state titles in track and field events that should have gone to girls and instead went to 2 boys. And so for Justice Kavanaugh to bring that up and remind the entire American culture what this is really about, it's about fairness and safety in women's sports, was really rewarding in the middle of a lot of legal gobbledygook.
Speaking of legal gobbledygook, I'm going to ask Erin a question that hopefully will go a little bit into the legal details, but she'll do it in a way that will make it understandable to our friends in the room that aren't lawyers. So the basic argument that the other side makes in this case is that the Equal Protection Clause of the United States Constitution prohibits sex discrimination. And so they bring what's called an as-applied sex discrimination claim. That dominated a lot of the argument today. The court wanted to know, what does it mean to have a claim like that? What does it look like? So Erin used to be a law professor. She still does teach some legal classes. So she is going to break down that idea for all of us and really expose why the arguments that the other side is making is so problematic and why there are troublesome implications across the board.
So I think that means I'm the resident legal nerd. But absolutely, this is fascinating stuff. And so what the court was really looking at was how equal protection challenges for sex work. So when you have challenges to race, then something called strict scrutiny applies. And as Justice Barrett noted, oral argument, strict scrutiny is almost always fatal. That's because the state has to have almost a perfect fit between its compelling justification and the way that it's accomplishing it. Its law has to be sort of perfectly attuned to the situation. But that's not true for sex discrimination because, as the court recognized in VMI and other cases, there are enduring differences that not only matter but are cause for celebration. And that means that some sex distinctions are okay. And the court arrives at that fact that they're okay by employing something called intermediate scrutiny. And so intermediate scrutiny asks whether the statute's purpose, here protecting fairness and safety for women and girls, is met by the statute, if it's a reasonable fit. Well, the problem here with the as-applied challenge is that the ACLU conceded it's a reasonable fit. Girls are at a disadvantage to men who are bigger, stronger, and faster. They can get hurt. They can't always compete. But, they said, for the small, narrow category of cases for circulating testosterone or whatever you want to look at, there's not that competitive disadvantage. The problem is, as Justice Barrett noted, as the Chief Justice noted, that turns the equal protection analysis for sex into strict scrutiny. It requires the state to have a perfect fit. And I think one way you can sort of get at this is Justice Barrett's question as to, well, if there has to be a perfect fit here, why then, if you have a non-athletic male, can't they compete in women's sports? And that's exactly correct. If the test is as applied, then there's no reason under plaintiff's theory that an unathletic male shouldn't be able to compete in women's sports. But that, of course, makes a mockery of Title IX, which was enacted to promote women's sports. It also makes a mockery of the Equal Protection Clause.
Good effort. I appreciate that. That was good. I followed it. So yeah, that's the very important constitutional issue that was raised before the court today, and the court struggled with it. Justice Barrett, again, raised it 3 or 4 times. It was something she was really concerned with. One of the other issues before the court today is something called Title IX. You guys have heard Title IX mentioned a number of times today. Title IX is the federal law that forbids sex discrimination in education programs. And our friends at the ACLU are arguing that that should be reinterpreted to also prohibit gender identity discrimination. And in making that argument, they rely on this case called Bostock. Bostock was a case decided in 2020, and it interpreted a federal law called Title VII that also deals with sex discrimination, but in a very different context, in the context of employment. And so our friends are arguing that that same logic in Bostock, where the court said that sex discrimination should include gender identity discrimination, that should apply here to women's sports, and therefore the other side should be able to bring down the Save Women's Sports Act. But our response to that has been, no, these are different. And so, John, I want you to walk through that a little bit and perhaps also point out what Justice Gorsuch said today, because Justice Gorsuch was the author of that case that our opponents are relying so heavily on. And so we all were hanging on every word to see if Justice Gorsuch thought that that was an appropriate comparison or whether he thought that Title IX, this sports law, is different.
Yeah, all the write-ups about the cases going in, all the legal Illuminati, were focused on this Bostick question and what Justice Gorsuch would say. In the Scarametti case, which also involved gender identity issues, he hadn't said anything and he didn't write his own opinion, so he was kind of a blank slate. We think that Title VII and Title IX are very different. They have different words. In Title VII, you are prohibited from taking sex into consideration in hiring and firing. In Title IX, you are required to take sex into consideration to make sure that women and girls are getting fair opportunities in athletics. And so that seemed like a pretty basic distinction. But Jim mentioned that the justice actually commented on this issue, and he did so in two really helpful ways. First, when he was addressing the attorney for BPJ, he talked about the spending clause and why this was spending clause legislation made a difference. All that means is that when Congress passes a law, usually a state has to abide by that. But when it's a spending clause provision like Title IX, it's a contract. The state doesn't have to do it unless it takes money from the federal government. And like any contract, you have to be really clear, if you're the federal government, about what conditions are attached to that money. And nothing in Title IX suggests that states can't have male and female teams. In fact, that was its whole purpose, and so that was a point he raised. Another is that there's an interpretive provision in Title IX, Section 1686, which says you cannot interpret the statute in a way that would prohibit male and female housing. And that isn't just an exception, it's an interpretive provision, and so it applies to the entire statute. As soon as you raise that, it's obvious that we have to take sex into consideration. So those are both very helpful things that makes it look like Justice Gorsuch is going to set Bostick aside and say this is different. But the justice who most surprised me was Justice Sotomayor, because at one point she said, well, of course, the Title IX regulations allow male and female sports teams, and so, of course, West Virginia and Idaho would be able to do that. And if you had Justice Sotomayor saving women's sports on your bingo card today, good for you, but that was an incredibly good sign for our clients.
Bill, I want to stick on Title IX and push a little deeper into the issues there and focus on something that the court talked about a number of times today. So the issue in this case is whether states can protect women's sports, whether if they make that decision, they're free to do so. But a lot of the justices wanted to know about another question, which is, does Title IX require states to provide sex-specific sports so that women have equal opportunities? Justice Kavanaugh asked that question to, I believe, every advocate that took the lectern, and a number of the other justices asked that question. So you, like ADF, are actually litigating cases where we're making those arguments. We at ADF went to the state of Minnesota, and we filed a lawsuit, and we're saying that Minnesota has to provide equal opportunities for women and girls because that's what Title IX requires. You're doing the same. Tell us a little bit about how that issue came up today and what your thoughts are.
Well, if Title IX is meant to ensure equal opportunities for women, then our view is that it must be interpreted to require that no men compete on women's teams. Why is that? Let's return to circulating testosterone. I mean, male and female bodies, we all know it, are different. The argument, though, that the other side is making with circulating testosterone is that if you can reduce that aspect of a male body, reduce the testosterone, then somehow it becomes fair and it becomes equal for men to compete, or trans-identifying men to compete in the women's category. And there, it's just a myth that the other side is propagating. The science does not suggest that. In fact, what happened in Idaho is that circulating testosterone language was drawn by the ACLU's expert from an opinion by a gentleman named David Handelsman, who is a distinguished professor in Australia and is an endocrinologist. His opinion said that was a significant factor, but he submitted an amicus brief to the court that said, while circulating testosterone certainly affects athletic performance, it does not say anything about the lifelong effects of higher testosterone, which begins in the womb. Even before birth, there's a mini puberty phase that many people aren't aware of, but endocrinologists are, that up until 6 months of age is the same or about the same level as what a male body experiences in puberty. So this starts a cascade of differentiation that changes the male body. So it's a myth to say that there's anything that can be done physically, including reducing testosterone levels, that allows equal opportunities. So the failure to address that issue ultimately means that we're going to have a country in which women will not have equal opportunities in sport in 23 of the 50 states.
All right, with that, our time is up, so please join me in thanking our panelists. Thanks, Jennifer.